Good afternoon, everyone. I'm Rafael Nicolazzi. I work in the International Public Policy team at Google. And today I have the pleasure to be here at CPDP, moderating this, what I hope to be a very insightful conversation about the intersection of the AI regulation with the AI Act, GDPR, what does it mean for innovation, compliance, and users' rights. And I'm very excited here to be seated right next to great 5 experts working on this field for quite some time. We have here international organization, representative, industry, regulator, think tank, and practitioner. And if the goal of today, I would say, is to, try to have a crystal ball and know how AI innovation can coexist with compliance duties, enforcement, and empowering individuals, I'm very confident that today you're all going to get very helpful ideas on how the present, but also how the future will look like. So with this great lineup, I think no one better than themselves to introduce who they are and how their work relate to AI and privacy. So let me start here by my right. Jacques, over to you.
Hi everyone. Thanks for the introduction, Rafaela. My name is Jacques Mondrian, and I'm part of the privacy team at Salesforce. I'm very happy to be here.
Good afternoon. My name is Jan Padova. I'm a lawyer with Woodson Sonnini, a law firm in Brussels. And that's it. I'm French, you can hear. I'm a former regulator, so nobody's perfect.
Indeed. My name is Natascha Gerlach. I'm the Director for Privacy and Data Policy at the Center for Information Policy Leadership, or CIPL for short. We are a global privacy and data think tank, and we've been working on the intersection of privacy and digital law for about 20 years now. And so and we've started our work on AI quite early on, and I'm excited to be here, and thank you for the invitation.
Hello, I'm Gwendol Legrand. I'm the Deputy Head of the DPP Secretariat, which provides the analytical, the logistical, and the administrative support to the DPP.
Hi, everybody. Clarisse Giraud. I'm the Head of the Data Governance and Privacy Unit at the OECD. Just a small thank you, Rafaela. Since I'm the last one to introduce myself, we're always grateful, Gwendol and myself, that we're given an opportunity to make public comments on what Jan was just saying, because he's our former boss at CNIL, so we always enjoy the opportunity.
Definitely a friend's conversation, yeah. And you're just here in the panel before, so Clarisse, you have a lot to share for sure. So yeah, so I think for the first round of questions, yes, and they got your photos right, so Clarisse and Jack are there now. Well, so for the first round of questions, I wanted to really start with the bigger picture, right, and context on where the world we are debating AI governance. And I think, Clarisse, the first one would go to you, right? So the OECD has been, I think, the first international organization to develop principles on AI. They're already out there. And I'm wondering, how do you envision those AI principles being implemented across, of course, you're in Europe, but let's start again with the broader context. And AI across the world has differences. Not all jurisdictions have AI laws at the moment. And how is this going to work, with different frameworks and with kind of how we're seeing the technological advancement over there?
Thanks, Rafaela, and thank you for giving me the opportunity to give this high-level overview before we dive into more bespoke topics. Indeed, the OECD AI principles are the first intergovernmental standard on AI. They date back to 2019. They were recently updated. They're just principles, as we say, but they provide a blueprint for policy frameworks to address AI risks and shape AI policies, and they've done so around the world and way beyond the OECD membership. And so what they advocate for is innovative and trustworthy AI, and under trustworthy AI, privacy features very prominently, and it's important to say they uphold human rights and democratic values. So the OECD membership is 38 countries and the EU, but there are 47 adherents, including 8 partner economies to these principles. And so what we have seen is that indeed these principles have irrigated into the national policy and legal frameworks around the world, including in countries like Egypt and Peru and elsewhere, but also in the work of international organizations and of course, the EU AI Act, we know the definition of an AI system in the AI Act comes from the OECD definition, and same thing in the Council of Europe and treaty and so on and so forth. So they are influential. They're non-binding, so I hear your question implicit. Countries, when they come and negotiate a text of that importance, really share a strong commitment to implement these principles in their national frameworks. And I can testify to the fact that there is a common belief across the entire membership and beyond that these policies and regulation later down the road is indispensable, because we face countries who basically say, we have not been really good, let's be honest, with social media. We cannot get it wrong this time. A regulation, it's the time of regulation, and this is where the AI Act comes in. Very quickly, they have been updated, these principles, just a few weeks back. Why? Because first of all, the development, the deployment, and the mass adoption of generative AI have triggered a lot of incidents, and so that needed to be taken into account. We also see that technical progress has been unequal and could potentially increase divides. And of course, I will only mention the language divide. Like, a lot of content is in the English language, and some parts of the world run the risk of being left behind. And also AI regulatory initiatives are growing. So we see AI regulation all around the world. So it is very important that we have somehow a common reference point, if you will, and not only a reference point in terms of principles and text, but also a forum where we can discuss these issues together. And that goes, of course, beyond the EU membership, but it includes the EU membership and the work of international organizations. It's very important to not see these international organizations as competing against one another, but as actually complementing one another. And that's really the spirit in which we've been working so far.
Fantastic, yeah. And I think building on this, right, I think there's a lot of work that overlaps, perhaps, or complements from CIPL that has been this very, thought leader on AI over the past 20 years. You guys have been early contributors on scoping challenges and defining solutions for AI governance, and also notably industry practices. And I think you published papers on that. One of them was 10 recommendations from policymakers to regulate AI. One very recently about best practices on AI. So Natasha, to you, what are the recommendations there? What trends do you see that are emerging from this field? And I think it also comes to this global scope that we were talking first.
Yeah, thanks, Rafa. So indeed, CIPL actually started looking at AI quite early on. And our first report on the potential tensions of AI and data protection principles came out already in 2018, and I know Jan will talk to us a little bit about that later on. And since then, we have looked at and made recommendations, as you say, for global AI governance. And we completed a report quite recently in February of this year on accountable AI, where we mapped how organizations are approaching AI or have been approaching AI in the space where no hard law exists as yet, so to see if we can, in fact, identify emerging best practices. And so in our work, relatively unsurprisingly, I think we came to the conclusion, obviously, that regulating AI is a very delicate balance exercise. A new study by the World Economic Forum shows that nearly 2/3 of adults expect AI-based products and services to profoundly change our lives in the next 3 to 5 years. And the AI Act sets out to promote the uptake of human-centric and trustworthy AI. So there is an expectation, I think, to continue innovating and developing in the AI space, but there's also a challenge. We see similar language for instance, reflected in the US executive order on AI, or in Singapore's AI governance framework. And we've heard this in the panel before very eloquently. The challenge is, of course, to ensure that the AI that already exists and the AI that continues to develop and accelerates in developing really, also continues to respect our expectations, not just of privacy and data protection, but they're including transparency and explainability and everything we expect in the context of data protection, but also human rights and security and intellectual property, and takes into account wider societal effects and impacts. So when we started to look at this from our global perspective and really in advance of the AI Act here, we sort of came to this onion approach, if you will, in sort of 3 layers. And so the innermost layer is a framework that has to define outcomes to be achieved by organizations in the AI space, with all the necessary elements and principles like fairness, non-bias, transparency, accuracy, security, and human oversight. So everything we would expect from it. And because a principle-based outcome, and so defining the outcomes we want to achieve, and then defining the principles that underfeed it, mean that the framework remains tech neutral, because 2 prescriptive elements, especially in a technology that's designed to continuously evolve, I always say it's a bit like trying to nail yogurt to a wall, right? Meaning it's not necessarily possible, and it means it renders the whole framework obsolete maybe quite quickly. And then the approach needs to be risk-based in our view. So it needs to look at applications in their context rather than focusing on specific technology. And one element is also making presumptions of high risk rebuttable, for instance, to ensure that we are really looking at where the high risk is, not where we just assume it to be. And also we need to look at risks holistically, meaning that it needs to include the benefits. Because really, especially in the context of emerging technology and in the context of AI, I think this reticence risk. So what do we as a society, or what does the individual potentially lose if we do not proceed? So that needs to also factor in the risk assessment. And then it must incorporate robust mechanisms to empower individuals, obviously, through transparency, explainability, and mechanisms for redress. And so that's the inner layer. And then there's the second layer or tier of our onion, which is demonstrable organizational accountability. Anybody who knows CIPL will not be surprised that we are talking about accountability. That's really our core work for the last 20 years. And this, in our view, should be a central element of any AI regulation approach to AI, similar to what we know, from Article 5.2 and 24 of the GDPR. And there are a number of accountability frameworks out there. I mentioned Singapore has one. Clarice talked about the OECD principles, and CIPL, for instance, has what we call the accountability wheel that has 7 elements that you can use to really set up your internal framework. And in our view, organizations must be able to demonstrate the steps they've taken towards fulfilling the requirements of the framework of the law. And then they also must be able to show the effectiveness of the steps they have taken, whether their risk mitigation measures work and how they do mitigate risks. And in our view, certifications and standards and codes of conduct are really excellent tools to demonstrate this. And then the final layer of this onion, in our view, is sort of the smart and innovative regulatory approach and oversight in tandem with co-regulatory tools. And that includes, for instance, sandboxes and cooperation-based regulatory mechanisms. And now we do see a lot of these elements actually reflected in the AI Act, in its risk-based approach, has accountability measures, sandboxes are an element, and the support of standards and codes of conduct. In my view, the AI Act is really an opportunity to cooperate and to engage and to learn together, and guidance from competent authorities, I think, will be appreciated. But I also think that the theme must be cooperation and coordination to avoid, fragmentation. We talked about the fact that, this emerges globally, and of course, most companies don't, at least in the AI space, are not located in just one jurisdiction.
Absolutely, yeah, those are very good points, and I really like the onion approach because I think it goes to what I want to ask Jan. So the two of you mentioned the AI Act, and I want to now start to zoom in a bit in Europe. And Jan, you also recently wrote about how the GDPR intersects with the AI Act. Right, this week we had the adoption of the final text of the AI Act. It's getting dates, but apparently that was the week. So tell us, Jan, from your perspective, what are you already seeing? And I think you also wrote another text, which was what Europe hasn't done right on AI. They're a bit provocative. So tell us a bit more about those texts, and what are the gray areas that you think, AI system developers will have to face when looking to those two laws combined?
Thanks, Rafa. I'm delighted to be here. And how many hours do I have to answer your questions? The question about the interplay between GDPR and AI Act is quite a complex one. And if I want to answer in one word, I'd say it's poorly articulated. Just from a start, if you want to set the scene, AI, generative AI, large language model, well, they rely on specific characteristics. They need large sets of data. The larger, the better. Data are messy by design. They are messy. We know that. And at the development phase, they don't have, the development phase, companies don't have a very specific purpose at that stage. It is still uncertain in light of, and the purpose will be more specific at the deployment phase later. So if you take into these three characteristics, large sets of data, messy and unspecific use case, doesn't fly well with the GDPR. Principles of minimization, not very good. Accuracy, messy, not very good. And purpose specification, not flying well either. So we can see that there's a structural tension between the two pieces of legislation, but at the very core, at the design of these two regulations. So that's kind of an introduction. So how is that articulated or overcome? Well, kind of not perfectly, to say the least. There's something funny, that in the AI Act, like in many European pieces of legislation, this is this famous sentence: this regulation is without prejudice of the GDPR. I think that's a joke. I like that one. For lawyers, it's paradise because it's indefinite legal interpretation, but that's not a real solution. And also it's complex because the drafting of the AI Act in itself is not of excellent quality. And I'm not the one that's saying that, from the outside. It's been stated officially by some key players of the AI Act, saying that it was, off the record, used as what shall not be done in the future for a regulation. So it's kind of the prototype of what should not be done in terms of drafting. But that's what we have. So we have to deal with that. So you can have the optimist view and the pessimist view. So I will start with the optimist view. So where the AI Act forces the tension and finds solutions. I'll give you two examples. The first topic where there is a solution is about repurposing of data, when there is personal data, of course. We all know that the AI models, when they rely and they train on large data sets, they usually acquire these data sets with third parties, and these data, they were collected for different purposes initially. So we know that the GDPR does not prohibit by itself the repurposing of data. It just sets like a high standard, a threshold that is quite demanding, since you must need to have a compatible purpose from the initial one to the further one. So it's not impossible, but it's a high bar. Now, so the last version of the Act provides a solution, an explicit legal basis for further processing, even for incompatible purpose initially, but that's the Article 59, but only when you are entering and exchanging within the sandboxes Natasha just mentioned, this is, this kind of safe space for innovation and experiments, which are provided by the AI. So in that case, there is a legal basis to have further processing, even if maybe initially they were not compatible. So within the sandbox, the question is solved. Outside the sandbox, the question remains. And I would refer here to the ICO guidance, say that calling on this public consultation very recently that there should be a flexible approach from data protection authorities. So I know that the ICO is no longer within the EU. I mean, that is sad, but that's a call for DPAs. I'm turning to my right, to my dear friend Gwenda, to have maybe a flexible approach of the purpose principle within an AI context. But that's at least a solution. So that was my first example. The second example where this tension is solved and overcome is for bias output detection. Say we all know that there's a risk of bias at the output level for the AI model, especially the bias is more likely to happen if the trained data had like a misrepresentation of a group of persons for any reason in light of, I don't know, their health, their sexual orientation, their political opinion, their ethnic origins, etc. So if the training data is biased, the outputs will be biased. And there are risks of this bias for the people. But in order to detect and correct this bias, you would need to process what we call sensitive data under the GDPR. You would need to collect health data, sexual orientation data, gender, whatever, ethnic origin in order to detect. But then you have a conflict potentially with the GDPR because there's prohibition in Article 9 of the GDPR with few exemptions that are not likely to work in this case. So here again, the AI Act finds an interesting solution. It's Article 10, paragraph 5. It said that providers of AI systems are allowed to process sensitive data, but just for bias detection and remediation. For this very purpose, they can process, and it is a specific legal ground to process this data. So it's built on the derogation provided by the GDPR. So these two examples are the optimist part of the AI Act solutions. Now, the pessimist part, where it's not well articulated, I had to pick and choose. So I'm going to focus on the allocation and the definition of responsibilities within the chain of actors that are involved in the processing for AI system. As you all know here, the GDPR is mostly focused and built on the notion of data controller. We all know that, we're familiar with that. The AI Act has a different notion. It's focused on the AI provider and less on the AI deployer. So these pieces of legislation, they were designed in silos, and this is where the key notions they articulate are not completely consistent one with another. And the articulation and the coherence of these two notions are not well addressed within the question. So especially this qualification, provider, deployer, controller, is likely to change in time, depending on your role and how you evolve. Let's say, at the training stage, when you are training the model, the provider of AI is likely to be the data controller because he's training, he's in charge, he has the definition of the purposes of the means, so the two notions coincide. They overlap entirely, 100%, that's okay. But then when you go to the deployment phase, when a company, an administration, whatever, uses that AI system in real life, then the deployer will become the data controller, most likely. I mean, most likely, it's just a theoretical analysis. And then you may have obligation under the GDPR, obligation to inform the data subject, if he takes automated decision to have an explanation about the processing, etc. And it's likely that the deployer, it's possibly that the deployer will not be in the capacity technically to provide the explanation because the explanation technically is on the provider. So here there's a kind of dead end, a loophole within these two pieces of legislation. There's some improvement at the final version of the AI Act. It's Article 13, when it says for high-risk AI, which is a specific category, then provider, where applicable, should inform in order to enable deployers to interpret the output of the high-risk system and use it appropriately. So enable the deployers to interpret the output. That is something, at least in the draft, that was not in the initial version. So that is an improvement to allow the deployers to fulfill their obligation under the GDPR. But I think the bridge here is fairly uncertain. A lot of the solution will, I guess, fall into the guidance that will come from all the authorities going to issue guidance on that, whether at the European level, AI office, or from the DPAs, if they have jurisdiction on that. So I will end up, but I end on the pessimist note. Sorry, I could have done the other way. But I see the interplay between these two pieces of legislation.
But you gave me the line to now turn to Gwendal to talk about the enforcement side of the story, right? Better saying the regulators side of the story. And of course, I mean, there's a lot of moving pieces, a lot of complexities. And Gwendal, you sitting at the DPD, you're looking a lot of that as well with the EU member states. So how do you think, Gwendal, the AI Act will have influence on this complexity? How is the DPD preparing to address all of this that is arising, right, from monitoring compliance both of the GDPR and I think some bits of the AI Act, right?
Thank you for the question. And first of all, I'm more optimistic, so I see the good side of the regulation. I think if you look what happens worldwide, there's a lot of countries and a lot of international regulations that are looking at AI. They're sharing common values, and I think we can be proud that the EU is the first region in the world that has adopted such a comprehensive regulation on a new technology, and it's likely to have a very broad impact. It's the first comprehensive law on AI, and it's clear that stakeholders worldwide are looking at the way we're going to implement it in the EU. I think as this was the case 6 years ago with GDPR, you know, when GDPR became applicable, there was a lot of people who were pessimistic, and when you look back, there's a lot of successes with GDPR, and I believe it's going to be the same with the AI Act. It's also very likely will have an impact globally with this regulation, because the EU is a very big market, and the way the regulation is drafted, so as Jan explained, it applies to a lot of different actors across the value chain, but it also applies to people who are offering these services in the EU, or people who are deploying systems that are going to affect people in the EU. And because we're a big market, it's obvious that it's going to have a positive and global effect to protect fundamental rights, to protect consumers, to protect individuals, and to create a level playing field in a context that provides rules also for innovation, which I think is important and was one of the concerns of the legislator. Now, when it comes to the interaction or compliance with both GDPR and the AI Act and the complexities that were highlighted before, indeed, one of the things that is important, and Jan said it, is GDPR is still there, it will remain, and the AI Act does not change and is without prejudice to GDPR. Okay, but the good news is, if you're compliant with GDPR, is a good starting point. Huh? There's a lot of things you already do about informing, about the way your processing operations are going on, being transparent, helping people to exercise their data subject rights, and so on and so forth. The AI Act, there's a big difference. GDPR is principle-based. The AI Act is risk-based, and in some aspects is much more prescriptive, than the GDPR. And I think this is an important, but it's also a welcome aspect, because it provides more certainty or more margin for interpretation, depending on the angle where you want to look at it. One of the core novelties, indeed, with the AI Act is that there's a number of systems that are prohibited because they're against the EU values. So there's one article listing the prohibited AI practices. It includes social scoring, it includes manipulative techniques, exploiting vulnerable persons, creation of facial recognition databases by scraping. I think there's quite a consensus on this. Huh? So it's very good that this is being regulated. And just as a reminder, the joint EDPB and EDPS opinion was also calling for additional prohibitions, which were not necessarily defined in the way we had proposed them in the final act, but there's points of attention on very risky practices that have been taken into account by the legislator. There's also detailed obligations for the so-called high risks systems and for GPAI models, okay? We talked already about the fact that there's different actors in GDPR and the AI Act. The AI Act captures providers and deployers, while the GDPR talks about controllers and processors. But as I said before, you regulate more people across the value chain, and the point that was made before about you need to explain something that is provided by somebody else is already a discussion we have to a certain extent when you talk about controllers and processors. When you buy a cloud service, for instance, or you use a cloud service and all the technology is provided by the cloud providers, to a certain extent you rely, but you need to understand, but you also rely to a certain extent on the security measures and the technical system that they provide. And besides, to be frank, I think there's challenges for monitoring compliance, both for organizations and also for the authorities. So for organizations, it's of course up to them to decide how they're going to be organized and who's in charge of compliance. But there's some interactions between privacy professionals, certainly, and people in charge of AI. So either it's the same people because it's about compliance, or they will have to talk together because AI is also about processing of personal data. From the authorities' point of view, which is very important, of course, coming from where I sit, at ADPB, we prepare, of course, for the AI regulation. You may have seen that we published recently the new strategy of the ADPB, and one of the pillars in the strategy of the ADPB is about interactions with other regulators and the new digital rule book of the EU. So this includes the DMA, which is about promoting innovation by facilitating data sharing. It includes the DSA, which is about fighting illegal and harmful content. And of course, it includes the AI Act. It means we're going to strengthen the dialogue with other regulatory authorities with the view of embedding data protection in the overall regulatory architecture to ensure consistency. Another challenge that is going to happen now is to identify at national level, but this is for the member states, who is going to be in charge of regulating the AI Act, because you know that this is left to the member states. It could be the DPAs, it could be other regulators. If the DPA, we think that we've said in the joint opinion of EDPB and EDPS that DPAs have a lot of experience when it comes to AI and they already regulate AI, and I'll probably come back to this later today. But if it's not the DPA, it means that there will need to be some dialogue between these authorities that will regulate the AI and DPA. So what is clear at this stage, I'd say, is that DPAs will have a clear role to play when it comes to enforcing the AI Act, and that the cross-regulatory dialogue will be key. And of course, at the DPB, we will aim to facilitate the understanding for stakeholders, and we're planning on issuing guidelines. This is also in our work program to clarify, inter alia, this interaction between GDPR and AI Act. And if you allow me, just perhaps a very short reaction also to what was said before. So there's of course discussions on the lawfulness of the training, how you gather data for the training, but there's also some good habits, I would say, that you should have taken from GDPR and that will remain valid when applying the AI Act, when to training data, for instance. So if you collect data for training purposes, use privacy by design for the use of the data sets, collect only the data that is necessary, minimize the data, erase all the data that the data that is not necessary, like the metadata that you gather if you have a database of photos and things like that. So these are good habits that normally you have already acquired with GDPR and that remain valid with the AI Act.
Absolutely. That's very helpful to hear, and I think you also helped me with addressing the question to Jack, which is, well, we heard a lot about regulators, international organization, think tank practitioners, but how companies are thinking about all of that, right, Jack? And like to finalize this first round, like how organizations are having to address all this ambiguity, and like what we are doing now at in Salesforce and with this new regulatory approach that is in front of us.
Thank you, Rafaela. I work at Salesforce, which is a cloud provider. And at Salesforce, we have the opportunity to assess the challenges that companies face with AI, both internally, because we use AI with our employee for marketing purposes, but also with our customer, because we can sell them services that integrates AI functionality. And when we get feedback from customer about the challenges that company will face with the use of AI and all the different regulation that we have in place, we usually have the similar concerns, similar worry, but we have also the same excitement. And the excitement is that the regulation is finally here. It's finally good. We're excited about having that regulation. I will not talk about the quality of it, but just to have it, it's good to have a regulation in place, because regulation helps secure the business. So that's very positive. And the challenges that will be faced by a company, I will start from a technical perspective. That's something that was said by Jan. When you use AI, one of the challenges that you have is the data quality. You need good quality of data to maximize the positive impact of AI. You need good data to make sure that you're going to get good and relevant prediction. And you need good data to fight against bias. So that's crucial. And data quality means data relevance. That means also data minimization. As said by Gwendal, that's principle that already exists in GDPR. And for companies, how can we achieve that? Because we have so many data. We process data all the time, and it keeps increasing. So we recommend company to use, you need to have tools to help you find the good data that are going to be relevant for the AI project you're working on. For example, at Salesforce, we have a service called Data Cloud that will help customer gather the data they need for a specific project. And it's not something that's limited to Salesforce. It applies to all platforms. And you have also, of course, different tools that exist with different providers. But that will help you get the data quality that you need to get the benefit from AI. And also just to finish on that, data quality and this type of tool that will also help you reach compliance, because you will be implementing data minimization principle. Another technical challenge will be, how do you protect your data? And I'm not speaking about security. I'm speaking about the value of your data. Your data is an asset for your company, and maybe you do not want to have an LLM provider keeping your data and training on it. So you can think about implementing contractual obligation when you sign agreements with AI providers or LLM providers to make sure that they cannot retain your data and train on them after they have processed it. At Salesforce, we have this principle of trust layer. So we have services that use OpenAI, and contractually, we have OpenAI. They are prevented to keep the customer data once they have produced the prompt. They cannot keep them. They cannot train on them. So that means that the data, they remain your asset and your value. And I think that's something to consider as part of the challenge with this regulation. And another challenge, I think, will come from the regulatory landscape. As Gwendal was mentioning, company needs to have an alignment on the regulatory landscape. We need to have an alignment on the key concept that we'll be applying. We will be devastated if each country has a different interpretation. That's the purpose of the regulation, but we never know. So I think from a regulatory perspective, an alignment that's crucial on the key concept. And then also from a legal perspective, at EU level, there is such an increase of data regulation. We have GDPR, we have the AI Act, we have DORA for bank and finance, we have the DMA and the DSA that Gwendal mentioned, we have the Data Act too. That's a lot. and it's hard to navigate among all these different regulation. It's hard to be an expert. I don't think, I cannot be an expert on everything, definitely not. I will rely on experts such as Jan, but I think in companies you need to, you don't have to be an expert, but you need to keep informed. You need to be informed of all the evolution of the regulatory landscape, because that's how you can prepare for the evolution of your compliance program. You don't have to be an expert, but you need to know, to keep informed and to know what's going to happen and all the different things that's happening. And then you rely on experts. and also for another legal challenge, that's what Jan mentioned, it's the number of roles and responsibility. We already have controller and processor with the GDPR. Now, we have a number of additional roles. You can be a provider, an importer, a deployer. That's a lot. So that means that companies, when they have an AI project, they're going to need to perform a case-by-case study to assess what is their role, what is the role of the different partner companies they are working with, and they're going to need to document that in an agreement because you have different responsibilities. And they're going to also have to take into consideration the type of AI they are planning to use. Is it going to be high risk? Is it going to be general purpose? There will be a lot of different obligations associated. So it's going to be a lot of work and some uncertainties. But I share the optimism of Gwendal. I think at the GDPR, we were also very concerned about this new qualification and these new roles. So I think market practice, guidance from regulator, that should help companies be able to capture this moment. And I have one last challenge I was thinking about. It's related to the workforce. When you speak with companies, one of the topics that comes back frequently is that they are interested in AI. They see, of course, the business opportunity, the value of AI. They want to go into that direction, but they don't have the expertise internally. So how can they do? So they can rely on external consultant. They can also, and they want to hire. But the thing is that when they want to hire, there is a shortage of AI specialists. And that's a very big challenge. How can you get AI specialists if the demand is higher than the offer? When we spoke about that issue with representative of the French government at Salesforce, and that's a big issue. And in many countries, like for example in France, it can take a couple of months, even a couple of years, to create a new academic cursus. So imagine if it takes you 1 year to create a new cursus and then 2 years of study. That means that you will have specialists available on the fourth market in 3 years. And no, that's too late. So it's a big issue. I think for companies, something you can think about, it will be to use internal reconversion. If you have performing employees that are interested in AI, you can try to create for them a new role. So you will have employees already performing within your company, who know the company and can be dedicated to something else. I do not advocate to give them more job with their existing role, but more to help them transition to a new function. And I think that will help for companies, employee retention and development of talent. Thank you.
Well, definitely a lot of job security for privacy experts, right? Even this conference changed the name to CPDP.ai, right? I think last year we didn't have the AI right next to CPDP. So that's great. That was the first round, and I took some notes, as you have seen. And let me just highlight a few of them that I heard from all of you. So I heard accountability, I heard regulatory tools, I heard large data sets. I also heard conflicts with GDPR. I really liked what you just said, AI literacy, keep informed, the regulatory dialogue, data quality, different jurisdictions. And I think that's quite helpful for like the first questions we wanted to address. So now moving to the second round, and I want to be mindful of the time. So we might have to speed up a little bit our answers. We're going to have like 20 minutes for the second round. And I want to go with you, Jan. And for the second round, I want to be a bit more practical and like what the things that are happening in the real world regarding innovation and again, compliance and respect of individuals' rights. And yesterday I was in a panel that you were speaking as well, and you said something that really struck with me, which was how many times we have the word innovation under the GDPR, and I'm going to ask the audience here if somebody knows. zero. Yeah, somebody said there. And in the AI Act, I'm stealing this from you. Apparently, it appears a lot more, but a lot more than zero is definitely already something, right? So Jan, in your view, like, what can we learn from the GDPR and transpose to those other regulations? And do you think that AI will have the same? I'm kind of getting you're the pessimist here in this panel, but I mean, what do you want to say more about that?
I'm not pessimist, but I'm cautious. And it gives me the opportunity to react to Gwendal's statement, because, you know, everybody here in Brussels believes that AI Act will benefit from what we call the Brussels effect, which is a notion created by the political scientists, meaning that the norms established in the EU tend to export themselves outside of the EU. And it's true, Gwendal said, but remember, Jan, 5 years ago, the GDPR, we had the same dots, etc. Well, I can explain, I think, why the GDPR benefited from the Brussels effect, and I can also maybe explain why, though I wish the AI Act will benefit from it, I sincerely wish, as a European citizen, as a practitioner, I have more doubts. So why did the GDPR benefited from the Brussels effect? First, the GDPR does not come out of the blue. For the ones that are old enough here in the audience, including myself, there was a directive 95/46 before, 95, 20 years before, 20 years of data protection practices in the EU, and in some member states, including Sweden, 1973, Germany and France, 1978, authorities and privacy regulations in place. So, I mean, privacy data protection regulation in Europe come from 25 to 30 years back. So the GDPR is not built on nothing, it's built on extensive practices and experience from several countries. And then GDPR also is a principle-based regulation. Gwenda reminded us rightly. It's a lot about accountability, some principles, and there's a lot of flexibility there because of that. And there's almost no prior checking. Unlike under the directive, you have prior checking from authorities on the directive. The GDPR has deleted all of them. So it's a principle-based, few principle-based regulation, no prior checking, a lot of flexibility, accountability. And as a matter of fact, it does not prohibit many data processing per se, very few. Some data are sensitive by themselves. I've mentioned them, what we call sensitive data, but that's about all. So it did set, and I'm happy with that, a standard. And since we know in my private practice we do advise global companies, it's true that since you have a standard, it's quite convenient to rely on it. It has an effect overall. It's a competitive advantage to some extent, because if you rely on that, then you have a set of values and the compliance that you can build on it worldwide. So that's why it was so successful. And in light of these characteristics, I'm not sure, dear Gwendal, that the AI Act will benefit from the Brussels effect. First, it's not based on principle. It's not a principle-based regulation approach. It is a risk-based approach. A risk-based approach means that you highlight risks. It's a kind of principle of precaution embedded in a piece of legislation. So it's a very defensive approach to some extent. It's not principle, it's a defensive one. And opportunities are a bit underestimated by design. If you highlight risk, you underestimate necessarily opportunities. And this approach, if we take a global view, because it's a global landscape, AI, it's a global competition, it's a global landscape, other very important regions, very important countries do not follow in this risk-based approach and will not follow, most likely. So, I mean, if you take into account, let's say, the executive order of President Biden of October last year, I mean, the drivers are kind of twofold. It's a complex, it's not a comprehensive piece of legislation. It has, intellectually, it's less satisfying. I mean, it's less comprehensive. It's less, even if the AI is poorly drafted, at least it's coherent. It's a piece of legislation. In the US, the executive order has two drivers. One is geopolitical, and the other one is industrial. Geopolitical is like the elephant in the room. And so it's really targeting China. I mean, it's a sovereign piece of legislation. some of the provisions of the executive order are based legally on the Defense Production Act. Defense Production Act. You see where it comes from. For instance, when a US provider of our cloud has the obligation to notify if a foreign entity uses their computing capacity to develop malicious cyber activity. So it's really hard. It's very strong in this driver. And the other driver is industrial. It favors funding from federal agencies and federal government to innovative companies, especially in semiconductors and biotech. So it's very targeted, and there is an industrial purpose there. So it's not maybe as satisfying, but it's very specific, and it's not a risk-based approach. So that's why I think the Brussels effect is less likely, because there are some core political choices, and not all the regions, and let alone Asia, will follow on that. And two other risks: the complexity of the AI, especially in its governance part. The governance part is really a maze. You can end up with, I think some countries are working on that, like 70 to 80 regulators, potentially in a country like France and in Germany. Good luck with that. And then, third point, there's a risk of obsolescence. Within the AI Act, you have like, for generative AI, you have a threshold in terms of computing capacity that is within the Act. It's 10.25 computing powers. Which regulation can have such a detailed threshold and believe it will last in years? Because let's be frank. Like 2 years ago, we were not talking about ChatGPT, OpenAI. At 2 years, 2 years is very short. This piece of legislation, some of its provision will enter into force in 2 years. So I see a really high risk of obsolescence of some provisions of this AI. So this is why I think it will not benefit from the effect, because it will have to be updated and revised, unlike the GDPR, which is a technological neutral piece of legislation. That's why I'm not that optimistic.
Well, I'm not optimistic about the timing that we have to go to 4 more questions in 10 minutes, but I will do my best. So I think I'll do 2 questions to Natasha and Jack, and then I do the second round for Gwendal and Caris. So Natasha and then Jack all together. So I would like you, Natasha, to speak a little bit about what you mentioned at the beginning, so accountability, like the onion, and what is this holistic-based approach, especially around how organizations are looking to the harms and the benefits of those technologies. Like, can you share a bit of the methodologies that you guys are recommending, a bit of guidance on that as well? And that's why I'm bundling with you, Jacques, so you can tell us a bit about what's the AI compliance program at Salesforce. So I will start listening to a few, and then we go for Caris and Gwendal for the last 2 questions.
Yeah, sure. It actually links to what Jacques and what Gwendal were saying earlier, because organizations in the EU usually have a privacy management framework in place, because we've had first the directive and the member state laws and now GDPR for quite a while. And so we see organizations basically bolting their AI compliance work onto that. Because also their privacy teams have experience and expertise on how to roll something this comprehensive out in a company. But as we discussed now, AI has very different challenges as well that have to be considered separately from just the data protection point of view. And you had mentioned, and I mentioned earlier, that we mapped how about 20 companies approached AI, and we mapped it to what we call our accountability wheel, which has 7 elements. And so we looked at each one of these elements to see how companies were linking their process to these elements. And so these elements are leadership and oversight, then risk assessments, policies and procedures, transparency, training and awareness, monitoring and verification, and then response and enforcement. And my boss calls this rules, tools, and schools for short, which I love, so I steal that all the time. But I'm just going to pull out a few points because we are short on time on what we have seen and we have this beautiful report, so if anybody's interested, I'm happy to share the QR code about it. But so, for instance, on leadership and oversight, what we've seen is sort of the importance of the tone from the top that sets the values within the companies of how you want to approach AI and what the direction of travel will be. And then there's a very strong understanding that AI governance must be multidisciplinary. I think that's really one of the key focal points. And we've discussed this, and Gwendal mentioned this as well, that it has to be cross-functional, and regardless of the final structure that the governance eventually takes, or who will ultimately be responsible for it within the company. And this cross-functional setup and multidisciplinary approach is important for the risk assessments to assess this, and Gwendal has outlined this. It's on multiple places in the AI Act where you have to assess your AI risk. And so in order for you to set up a risk taxonomy within the company and to be able to assess this risk, it's vital. And we find that companies are aware of that this is done by a cross-functional team. This obviously translates into cross-disciplinary internal policies as well, and training. And I think Jacques outlined this really well, that there is a necessity within the company to develop this AI literacy, and the AI Act itself, Article 4 talks about this. And so this goes beyond just privacy and technology, but it may involve also ethics, for instance, or considerations of competition in order to do this in a holistic manner. Then transparency is another huge piece of that puzzle. For one, and this will depend on who's on the other end of the transparency, right? The individual, so me, will need very different information than, for instance, a regulator will need. And also it will depend on who is dispensing this. Is it a developer or a deployer? And to whom? And maybe it's a developer sending information to a deployer. So there are many different factors to how transparency needs to be structured in this. And then one very important aspect related to the monitoring and verification is the clear realization this is an iterative process. It's not a one check and you're done. And it's an ongoing monitoring and validation loop that also has to build in the proverbial human in the loop into the process, and mechanisms to audit not just what goes into the model, and we've discussed the data quality considerations, but then also what comes out, and that was really well discussed in the panel before. Many companies set up red teaming and similar adversarial testing methods as useful tools in combination with feedback loops, for instance. And again, as I mentioned before, certifications and codes of conduct are embraced here really as very valuable tools. And then, of course, redress is a big part. How can I make my concerns known to the company? And that's also, of course, a piece of this continuous verification process, because every complaint that goes in must feed into, this loop of verifying that your AI is functioning properly. And then, enforcement, of course, in the end, for when something does really go wrong. And we've started an AI implementation project where we will look into this in more detail and all the different bits and pieces, and happy to chat to anybody about that who wants to join us. But I'll stop there and give Jacques some time.
Thanks, Natasha. Thanks, Rafaela. I agree with Natasha. For your AI compliance program, you don't have to start from scratch and build another program. Whether you should use the compliance program that you already have, if it's effective, and then you can build on top of it an AI layer, because as we discussed, there is many topics that interconnect. For example, when you do an impact assessment, it's very probable that you're going to have to perform data protection impact assessment, and you can have also a layer on that. how we approach the program of AI compliance at Salesforce, the first step was to define our AI vision, similar than the privacy vision that is recommended under GDPR. So what was our AI vision? What is the AI vision that your company wants to implement? What are the core value and core principles you want your company to do with AI, what they could do and what they should not do? And that's like a North Star that will help your company going into the good direction. And that's also something you can use for alignment with your company. So first of all, to build our AI vision, so we published our trusted AI principles with different core values. Transparency, that's one of them. Empowering the people. Inclusiveness, to make sure that AI capture all the person that are concerned. So first of all, your AI vision. Then build an AI committee. This committee will be composed from different experts on AI, but also representative of different teams within the company that are impacted by AI project, and they will have a role of supervision and consultation. Once you have done that, you follow the guidance from regulator. We are lucky to have in Europe regulator that provide robust guidance, so you try to follow that. And I'm going to go very fast because I'm conscious of time. I will say also a very big part of your compliance program is the impact assessments and the documentation. That will be the key. That will be the key to I think we should see impact assessment not as a potential liability, but as a tool that drives value, because that force team members, different teams, to bring together and to share in one single source of truth their input. And once you have an impact assessment, that's also something that can help your management and your company take informed decision. They cannot ignore the different risks and the different aspects. So I think that will be the main topics I wanted to discuss.
Fantastic.
Thank you.
Thank you so much. And I like what you said about bringing people together, because I think it goes to the two last questions I have for Clarisse and Gwendal. So I will bring them together as well, and then you can address. We still have, I think, 10 more minutes. Yes. But so for you, Gwendal, is on the EU coordination. Like, can you elaborate a bit more? You know, I think you already spoke about the DPAs, but there's also going to be, a AA office coming up, a EA board. So tell us a little bit more about how you plan to work with all this ambiguity that you spoke a little bit. And then I think to you, Clarisse, tell us a bit more about the OECD expert group on AI, privacy and data. Because I think, again, it brings people together, like those two efforts you guys are working on in different fronts, of course. But yeah, I will have to finalize with those thoughts from the two of you.
Thank you. I'll start. So first, a reaction. There was this comment before that regulation, GDPR, was built on a lot of experience and things like that. At this time, I also remember people were complaining that regulation was too slow, came too late, was not keeping pace with the technologies. So this time we have something that's timely and more specific. So it should be welcome, at least by a number of people, I think. And on the obsolescence, if I make a parallel with GDPR, and also because you talked about DPIAs, there's, in GDPR, this obligation to have DPI lists adopted by authorities. They're not updated every day. So indeed, you may need to update certain things, but the pace at which you update is also, I think, acceptable. Now, when it comes to challenges on enforcement, which was the meaning of your question, I see three main things, I would say. Managing expectations, organizational challenges, and challenges related to the substance itself. So managing expectations. First thing, when you have a regulation, of course, one of the usual challenge is how you have effective oversight and robust enforcement. And special attention is paid today to the AI Act because there's strong finding powers, especially for some prohibited practices, because it can go up to 7%, which is a threshold that is higher than GDPR. So it means important powers for the authorities, which will require robust procedures. Organizational challenges. So we talked a bit about the governance of regulation, which is complex to a certain extent. And indeed, there will need to be coordination. There's the EU AI office, which will have a lot of investigatory and enforcement powers when it comes to GDPR models. They will develop also some guidance together with the new AI board. The member states have to adopt these new authorities in charge of AI, and you need to the member states will also have this task to facilitate the coordination of the authorities, to make sure between the market surveillance and the other authorities to make sure that it is going smoothly. And as I said before, the AI Act does not affect the GDPR obligations. And for the GDPR obligations, as you know, and I won't have time to go into the details, but we have our usual cooperation toolbox at EDPB, where authorities work on cross-border cases together, and the DPA and the EDPB intervenes in case there's disagreements between the authorities at national level. On top of that, we have also toolboxes related to our working methods. So we have the coordinated enforcement framework defining priorities at EDPB level, where authorities work in a coordinated way on a priority topic that is selected every year. And we have task forces like the ChatGPT task force. Today we had an EDPB plenary. A report of the ChatGPT task force was adopted and will be published very soon. And then the challenges on substance. So I don't want to preempt any DPB guidelines, but if you look at what people have been doing at national level, there's certain topics of interest that come up quite regularly. Transparency, lawfulness, fairness, data protection by design, web scraping. So these are common topics that authorities are looking into. And of course, if you look into the details, the specifics of AI, it's important to break down the different parts of the AI systems. So there is the collection of the training data, the pre-processing of the data, the training, the prompts, and the training with the prompts afterwards. So you have to think about all of this to make sure that you manage the compliance of the systems. I don't have time to elaborate more, so I will give the mic to Clarisse.
Merci, Gwendal. Always, I feel for the regulators. I was one not so long ago. It's so tough to be a regulator. No one ever thanks you when things go fine, and everybody gets complaints about something. So anyway, well done, Gwendal. No, I'm joking. But what can the organization that I represent do to help? That was the question that we asked ourselves a year back. We're not working on the AI Act. We're not businesses. We're just, but how can we help? And basically, 18 months back, I walked down the hall and walked into the office of my AI counterpart and said, we have to work together because, it's a lot about data in your space, and you're working on your AI principles, but, we see that regulators are coming up with guidance, enforcement decisions are being handed down, and not only in the EU, also outside, so we need to do something together. And that's when we decided to create, we, not us, our two working parties, meaning the working party on AI governance and on data governance and privacy, meaning the countries themselves, accepted to create an expert group, a joint expert group on AI, data, and privacy to look together at the different challenges ahead. And so that means that we really wanted the two communities, the so-called AI community and the privacy community, to come together in all their components, and they're very varied, to basically put their heads together and look at where there are intersections between our respective frameworks and mindsets even, and where we could find areas of commonalities and of course challenges, but mainly commonalities, so that we could basically work further and be optimistic. So I'm on the optimist side. And we've actually found a number of topics that are extremely important, both in the AI principles and in the privacy principles that we commonly use, indeed fairness, bias, transparency, and so on and so forth. And when you talk to AI people, if you will realize that they talk about different things from what we discuss when we're in a privacy setting. Then also the AI folks realize that actually privacy laws encroach on their field much more than they thought. And it's actually a really interesting educational exercise nearly. And we've used, well, what Gwenda was just saying, actually the AI lifecycle that has been adopted by the OECD as part of the recommendation on AI as the basis of the work. And we're actually looking at, as the AI lifecycle proceeds, where do you have privacy constraints, privacy issues, how can we work together and alleviate them? And that takes us to work on pets, but also to look at how automated decision-making provisions can already apply to some situations that could be covered also under the AI Act, if we look at the EU and so on and so forth. It's a super rich exercise, very exciting, very high level people contribute. Of course, DPAs, but also representative government, research institutes, et cetera, and we will soon publish a first report, and further down the road, we will publish guidance, case notes, and so on and so forth, and that's how we hope to play a role to facilitate the integration of both.
Fantastic. We're 1 minute ahead of the time, so that's great. Well, I heard great keywords as well that I took notes in round 2. I heard Brussels effect. I took note of pessimism, heard many, many times. Accountability wheel, oversight, multidisciplinary, transparency, testing methods, certifications, redress, principles as North Star, impact assessment, bringing people together, cooperation toolbox, priority task forces. I heard optimism in the end, which I took note as well. Well, you mentioned something that I think it can be a panel per se, which is pets, right? Privacy-enhancing technologies. I mean, I just want to say that from my perspective, it is a to-be continued conversation. I think it's quite amazing to have basically the majority of the panels of these days together about AI. There's so much to talk about it. I mean, I'm a super optimistic on this topic as well, at least as a privacy nerd. I think we are in the moment of time that we have many more questions than answers, and that's quite fascinating. That's why I think it's so great to have all of you here discussing it. And yeah, and I think just to be continued, I don't think we have time for questions from the audience because we're definitely at time, and I think we have a panel after this one here, and I want to be respectful of the others that are going to be on stage. But I think all of our speakers will be around here if you'd like to ask any questions for them directly. Thanks a lot to all of you for coming. It was great chatting with you all, and yeah, to be continued. Thanks so much.